Remember back to when we were learning about product liability law in Chapter 7, one of the steps of the evolution of that law was to change from this contract-based theory of recovery and into a tort-based theory to allow people who are injured by dangerously defective products to escape that economic loss rule that we're limited to with breach of contract claims. We're limited to just recovering economic losses and not special damages. Now the theory there, back when that was the rule, when it was a contract-based claim, was that by injuring you with a dangerously defective product, the manufacturer or somebody in the line of distribution had essentially breached a warranty to you of representation, express or implied, about the safety of that product or the fact that it should be expected to be basically safe. Now, that's not how we assess product liability claims now. It's a strict liability tort claim. But there are still breach of warranty claims under contract law that you can bring separate or in addition to that. So it might be part of a product liability claim. You may also be able to prove that they breached warranties. And you might also, even though product liability is strict liability, you might also have a negligence claim in there for something that they did, that if you can prove that they behaved in a negligent or reckless manner or an intentional manner for that matter. But right now, that's what we're going to move on to, are sales warranties, representations about goods that we purchase and goods that are sold. So let's move back to our slideshow. Sales warranties is the second part of this chapter, Chapter 11, on the Uniform Commercial Code and the sale of goods. Now, what is a warranty first? A warranty is basically a representation about the goods that you're buying that we would expect a reasonable person to rely on in the purchase and use of the product or in the decision as to which product to buy. Now, a lot of warranties, there can be pretty much an unlimited a number of warranties about the product, because there's an unlimited number of ways that a product of qualities or attributes that products can have, whether it's a bottle of shampoo or a car that you buy from a dealer. All sorts of things that might be important to somebody or could be represented about the product. Now, there are also implied warranties under the law, and we'll talk about those in a second. But first, I want to look at express warranties. These can be things that are stated to you about what the product can do or what it can't do. It could be represented by simply showing you an example of what the product is supposed to look like or what it's supposed to how it's supposed to function. And you'll see disclaimers about this a lot, because people who sell goods, they want the product in advertising to look better than it is, right? So that's why you see a lot of times a picture of cereal on the box, and then there'll be a disclaimer that says this is not exactly what it looks like. It's not really, this picture has been enlarged to show the detail, because they want to make sure you understand that they're not warranting to you that that's exactly what it's going to be when you open the box. So these are a couple of examples I just found some time ago on Google to just kind of explore some examples of how these warranties can be made and why they're relevant. But also it's important for us to compare what is a warranty, and thus something that you should reasonably rely on in making a decision or in defining your expectations about the product, and something that is not a warranty that sometimes is called puffery, something that you say about the product that, it's just intended to add some adjectives to make the product sound like it's a superior product, or to make it sound really cool, or whatever else you're trying to convey. But they're things that you can't really define, and so they're not considered warranties that you could rely on. So let's just look at some examples with these two real products. So on the left you see Supreme Kosher Classic Frankfurters. Now at the very top we have two words there, Supreme and Kosher. Now one of those is a warranty and one is not. Now kosher sometimes is used as a sort of puffery term. Sometimes people, as a colloquialism, use it to just mean something is, legitimate or good in some other way. Here, though, because it's dealing with frankfurters, with meat, it has a specific purpose, and that is something that can actually be can actually be verified, and we would expect people to be able to rely on that. It's an important part of people's religious practices. And if you look down at the bottom, down there at the very bottom on the same side of the package, you will see the rabbi's name who actually certified that these were kosher. So that is something that can be relied on, and we would intend, and they are intending for you to rely on, and they're actually backing it up there by telling you where and by whom it was certified kosher. Supreme hot dogs, can we really rely on that and complain later? Can we bite into a hot dog and say, this isn't really quite supreme? No. So we can't really define that. It's something that's kind of indefinable, and it's just put on there to be as part of their marketing. We could go through quite a lot of these. Of course, the ingredients are very important. They're warranting to you that that is what is in there. Another important one on the bottom left is the net weight. 32 ounces there, or 2 pounds of food product. That's important to people when you're looking at the price of it, to know what you're paying for and how much you're getting per ounce or per pound, as the case may be. And then you have nutrition facts that, again, something that you would expect to rely on. If it says it's got 100 calories and it has actually 400 calories, you would be upset by that, and you should be, because that's assuming that you care about the calories, because you've made a decision that you probably wouldn't have otherwise, and paid for a product that you wouldn't have but for that representation. And there was an interesting case not too long ago that Subway restaurant won, where the issue was about them representing their foot-long subs, and the bread, it turns out the sandwiches were not actually always a foot long. Sometimes they were 11 inches or 11 and a half. Now, normally that would be the case where, yes, I mean, if they're saying they're selling you a foot long for a cheap price, then you expect that you're selecting this because you're getting more for your buck. That's maybe why you're going to Subway. But in that case, the court ruled in Subway's favor because of the nature of baking bread, and that it wasn't reasonable for people to expect that it would be precisely 12 inches every time. And it was close enough that it wasn't really considered a breach of the warranty. They were basically attempting to make foot-long sandwiches, but it just wasn't reasonable to expect them to measure out each time and get it perfect. The next one you see there, Chef Shabaz's original fish chili. So first, it's chili. We expect it to have fish in it. That's something. And then below that, it says no beef and no beans. I don't know. I mean, it would be relevant, I guess, if you're, I don't know, what is it called, a pescatarian? I think that's what it's called, where you're a vegetarian, but you still eat fish. So you could rely on those things. The net weight there, again, it's supposed to be a pound of food. It should be. You should be getting a pound for whatever you're paying for it. It says it's the original fish chili. Can you really define that? Maybe, maybe not, probably not. But and then importantly down there's a seal that says it's wild caught fish. And interestingly, it doesn't say what kind of fish it is, so it might be a variety of fish or fish product. And then it says chili redefined. Can you really bite into this and then say, well, it doesn't really taste like a new definition of chili? Again, that's something that they're just saying to build up the product. It's not something that we would expect people to rely on and be able to complain about. So those are express warranties, and you can see how some of the ones I'm mentioning probably they wouldn't cost you necessarily a lot of money, so they might not make a good case. But you could expand those into a larger product where you have more money, and a dealer sells you a car, for instance, and promises you, maybe in writing, that the car gets 30 miles to the gallon, and in fact, or maybe the manufacturer warrants that in the information sheet, and it actually gets 20 miles to the gallon. Over the course of you driving that car, that's going to add up to some money that you wouldn't maybe have expended on gas if you had known the truth. And so you may have, again, a breach of warranty claim there and some substantial damages potentially. Now, we also have, under the Uniform Commercial Code, some implied warranties that are implied by law, whether the seller adopts them or not. So whether you say these things or not, the law implies in every contract that these are representations that are being made by virtue of you selling products as a merchant. Now, there's two on here. There's another one, the implied warranty of title. We don't spend too much time on that, but just so you know, the UCC has an implied warranty of title that says if you're selling goods, it's implied that you were promising you own title to those goods. I think everybody kind of understands why that is. So if it turns out you didn't owe them, if you didn't own title when you sold them to somebody else, that person would have a breach of warranty claim against you on that basis. The other two are called implied warranty of merchantability and the implied warranty of fitness for a particular purpose. The implied warranty of merchantability basically means that the goods are going to be, whatever they are, they're going to be fit for whatever goods of that kind should be used for. So if you drive a car off the lot, if it's a new car, and it just all of a sudden stops driving after you've had it for 2 hours, that's an implied warranty of merchantability, because nobody could sell a car, any car that only lasted for 2 hours, nobody would ever buy, right? And so that's why it's implied under the law that it has to be drivable for a reasonable amount of time. It will have problems eventually, but not one that just immediately breaks down. Now, there's also the implied warranty of fitness for a particular purpose. This arises when the seller has reason to know that you're expecting to use the product for a certain purpose, and they know that you're relying on their judgment, and they sell you a product, even though they don't say specifically, this is the one that will do that thing that you want it to do. There's still that the law still implies that warranty on them. So I'll give you the example I always use is you go into a store and you want to buy a food processor, and you go in and you say, I'm looking for a food processor, to the salesperson, and you say, I want the best, I want the strongest one, I want one to pulverize food so that I don't have to process it, pre-process it at all. So I want to just take a whole apple and I want to throw it in there without peeling it, without cutting it up. I want to throw a whole orange in there. I want to use every part of the fruits and vegetables and the juice, so I need that kind of food processor. And then the seller says, without saying anything else, says, I think I've got the one for you, and he points you to one, and he says, I think this is the one you should buy. And you take it home, and it's complete crap. It barely processes anything. Now, he never said to you on paper or orally, he never communicated, this will do that exact thing, but he knew that you were relying on him when you told him what you were looking for, and then he gave you this product. And so that's why the law implies that you will warrant that in that situation. So these will be implied whether you promise them or not, but they can both be disclaimed, and you'll see in contracts, in sales agreements, a lot of times you will see these disclaimers. These disclaimers need to be conspicuous, obviously. As with all disclaimers, really, anytime you're getting somebody to waive rights, you want them to be conspicuous, bold. You don't want to try to sneak them in there, because some judges in some jurisdictions might not like that. To disclaim the warranty of merchantability, in particular, you have to say that that's what you're disclaiming, or you can use language that indicates you're disclaiming all warranties that might otherwise be implied by the law by saying things like as is or with all faults. And this is why if you go to a used car dealer, I talked about driving a new car off the lot and it breaking down after 2 hours. Well, used cars, some of them, if they're old enough, they might break down pretty soon after you buy them. Maybe not 2 hours, but pretty soon. So if you're looking at used cars, the sticker will always say, in big bold letters, it'll say "as is" up in the corner, and so that should always be the first thing you should address when discussing the car that you're trying to buy. Is the first thing you should say is, "Well, I really like this car, but I don't think I can buy it like that." And they'll probably take it off and say, they'll want to sell you the car, but why not put it up there, right? They're going to try to. You might as well put it on all the cars, and if somebody buys it, then they will not have implied warranty. So if it breaks down immediately, if you bought it as is, then you're stuck with that, because they were able to disclaim and and get out of that implication under the law that they're warranting merchantability and or fitness for a particular purpose. So always, watch out for that. And a lot of times it can be negotiated, but if the seller can do it, they might as well put it in the agreement. And as long as you don't say anything, then it'll work out really well for them. And that's actually what happened in this case. This guy bought a boat, and which is obviously a significant purchase. It's an expensive purchase, and I think after about 3 years, it was a new boat, and after about 3 years, it started to completely deteriorate. And pretty soon, an appraiser determined that it was a complete loss. And that's a huge loss after 3 years. However, he did not do the thing that I'm suggesting, which is to read what their warranties are. And they had some disclaimers, and the court noted they were in all capital letters and said a reasonable person who looked at it would notice them. And they had specific disclaimers saying that they were disclaiming the breach of, disclaiming warranties of merchantability and fitness for a particular purpose. You don't want to sign, especially when you're buying something new, you don't want to sign something like that. And with such a big purchase that, probably they'll be fine with chucking it out if that's the difference between getting you to buy a boat versus not. But he was completely out of luck. He bought this boat that completely fell apart after only 3 years, and they had protected their contractual rights, basically. So there's a slide under the book. In the book it talks about different ways that the seller and the buyer can breach the contract. We've talked a little bit about that. I'm not going to spend too much time talking about that, but and then some rights as to what you can do. I'll let you pause that if you want, and you can read over that on your own time. Some more examples there of different situations. And now I want to end here. I want to end this video by talking a little bit about damages, namely consequential damages versus incidental damages. We talked about punitive damages and maybe expectation damages, like money you were expecting to make. Consequential damages are damages that occur that the breaching party, that could have been foreseen to the party who's breaching, that if they breach the contract in this way or that way, these are the damages that they would be able to reasonably predict that you would suffer. Incidental damages are things that you wouldn't necessarily know ahead of time until the issue came up, but they're an incidental and natural part of the consequences. So they're all the little things that you have to pay for to kind of fix the issue. So I just want to look at a case to sort of show you how that works. And so what we have here is this is a case, the television shopping network QVC has this portable, a little space heater, a little electric heater, and it's made in China for a company called Soleus, and Soleus is selling them through QVC. So QVC is doing the sales, and Soleus is the one providing them, again, made by another company in China for them. So eventually they sell over 19,000 of these in the span of about 1 year. Eventually, as happens sometimes with these space heaters, there's some safety issues. They overheat, and they can cause some burns or maybe even a small fire. They had a problem, I believe, with the cord that was producing was overheating or was helping the product to overheat. So when these issues get reported to QVC, QVC does what you should always do in this situation, and this is something I haven't expressly addressed. But whenever somebody's caused you some damages, it's incumbent upon you, and you're obligated to mitigate those damages to the extent that you are able to. So if a tenant breaks their lease and leaves, you need to try to get somebody else to move into the apartment. You can't just let it sit there empty. You can if you can't reasonably find somebody, but you have to try to get somebody in there so that you're not missing rent. You can't just sit back and just let the apartment sit empty forever, and then expect a court to make that person pay for all the damages that were in your power to mitigate that you didn't. And so that's what QVC is doing here. They stop the sales, obviously, and they start contacting customers and start trying to fix the issues to mitigate the damage and the destruction that's happened after these with the safety problem with the heaters. So they order a recall, they start contacting customers, as you do in these situations, and they give them options. They say, look, there's a safety problem. You may not have experienced it yet, but we want you to know we will refund your money, we'll take the product back. They also gave the option, they said, if you just want to return the cord to us, we'll replace it with a safer cord, because that's the problem that we've identified. You know, if you don't trust that, that's fine, we'll take back the whole product, but they give them some options as to what to do. If you've had a car issue, you know, a lot of times they'll do recalls on certain parts of a car, and they're going to mail you just continuously saying, just a reminder, you know, you can take this to a dealer, we'll do it for free, we'll replace it. And they're going to keep doing that because they're trying to mitigate damages and not be liable, particularly if something hasn't damaged you yet and they know that they can prevent damage or injury from by warning you and offering to fix the issue. So they do all of that. And this case is really about damages, and it's also, to me, about a really bad contract drafting. So Soleus owes QVC damages from this incident. It wasn't QVC's problem. They were just selling them for Soleus. So there's some obvious consequential damages. One, they made some money, and now they're having to refund a lot of it. So they've lost a lot of profit. That's an obvious consequence that any seller of a product could foresee. However, there's also some incidental damages, and it was really easy for QVC because Soleus' own contract agreed to indemnify QVC, as you see at the top there. This is their purchase order. And if you don't know, indemnify just means to pay back somebody for something that they've suffered because of your fault. They agreed to indemnify QVC, it says in their own contract, quote, for direct, special, exemplary, and consequential damages and losses of any kind, including lost profits and their attorney's fees, quote, based upon or resulting from any alleged or actual defect in the heaters. So they promised in their own agreement to pay for even alleged defects. So they didn't even have to show necessarily that the defect was real. They were offering to pay their attorney's fees if somebody alleged or accused them of having a defect in the heaters. So it was, even though it was their contract, Soleus's, it was really a better contract for QVC. And so it wasn't a problem for them to get their damages. In total, almost $1.7 million. And you can see here, try to zoom in here. I don't know if this is going to let me do that, but you can see here how these are broken out, and particularly you can see some of the incidentals. Just in the section of other recall costs, you have the cost of sending the letters, service calls to the customers. They had to get it tested by an expert to know what the problem was, so Soleus has to now pay for that. There were additional recall letters sent, all the phone calls to the customer, potentially maybe some more hours that had to be worked by some employees. And you can go through and see a lot of those and how the court goes about assessing these, not just consequential damages, but things that are natural incidents that, you know, Soleus maybe couldn't have predicted all of these, all of what it would take to fix the problem, but they did naturally arise, and they were necessary in order to protect QVC's interest and to protect consumers. Last note in this chapter is about the Convention on Contracts for the International Sales of Goods. Just a quick note about this. This is kind of like the UCC, but in the form of an international treaty, and these are the countries that have signed on to it. So if you're doing business with one of these countries, you may want to, it may be helpful for both of you to agree to be bound by this, because it's like the UCC, it's a uniform set of rules that deal with the sale of goods that will give you a uniform set of principles between two nations that otherwise would have very different laws. And so that's true of a lot of domestic law here. There are international treaties that seek to unify on a certain area of law, the laws between our country and another country. Again, that may otherwise have very different laws. It gives us this sort of thing that we can agree to, and that way we know what rules we're playing by.